your charter right is never going to be considered by a U.S. court. So if we were to actually carry out this executive agreement, the U.S. courts would never, ever weigh the Canadian charter rights. We lose our charter rights. We always thought that if data was in Canada, it would be exclusively under Canadian jurisdiction. But the Americans put together a new piece of legislation called the Cloud Act. And the Cloud Act, what it says is that if you have a U.S. company or a U.S. sub, or you connect through the U.S. in some way, or you have a minimum connection with the U.S., then the U.S. is able to regulate that data, take that data. And so let's just think about what that means. So Microsoft, Amazon, right? Okay, so Google, Meta, we all know they're American. Okay, so that's one step. But what happens when you have Canadian companies that just happen to have U.S. connections, like TELUS? It has 1,900 jobs in the U.S. Or BCE, which has substantial U.S. investors and is interlisted on U.S. Stock Exchange. They meet the U.S. regulatory minimum connection test. Same with Rogers. So all of a sudden, our telecom providers holding all our cloud data in Canada are subjected to U.S. regulation. But it gets worse. Why? Because Canada has decided it wants to engage in an executive agreement with the Americans to circumvent our existing, we have a thing called a mutual legal assistance treaty, an MLAT. The MLAT requires a faster way that you can seek evidence in Canada, for example, for a U.S. court, but it still has to be reviewed by Canadian authorities and by Canadian courts. Now, in Canada, we have a privacy right under the Charter to data. In the U.S., they don't. In the U.S., when you give your data to a third party, you have a lower right, a lower expectation of privacy. Our courts have said, no, you have the same right. So therefore, your charter right is never going to be considered by a U.S. court. So if we were to actually carry out this executive agreement, the U.S. courts would never, ever weigh the Canadian charter rights. We lose our charter rights. We lose that over our privacy data. We lose it over our financial data. We lose it over our health data.
And what does that mean for our children? I guess that's the key.
This is everything you want, because it deals with facial recognition. It deals with your ability. It also deals with your ability to regulate. So you need to be able to have that capacity. So the question is, A, who the hell had this idea that it would be good to actually sign on and agree to this legislation through the executive agreement? Okay, that was not a good idea. 2, why aren't we putting blocking legislation to prevent that right now? Do we want to be surveilled? No. We need to protect that, and we need to ensure that. And that has to be a say in Parliament. That has to be a say by Canadian courts. I don't want any American court ruling on Canadian data. That can't be right. And then what happens when we have a different standard about child protection, or a different standard about how we want to regulate AI to ensure that shooters can't go and shoot children in our schools? And that's going to be different from the U.S. standard. And they're going to say, oh, you can't do that. That's going to be a violation of the trade agreement. That's our third piece. The trade agreement. Actually, we agreed in the CUSMA to provisions that would not allow us to do that. And that was a serious mistake. And that's something we got to fix in this round now. We cannot allow that to continue.